In the wake of the Supreme Court decision just a few weeks ago, my colleague wrote something and I want to get your take on it. They wrote this: businesses won't be able to rely on top schools for a diverse pool of applicants after the Supreme Court's affirmative action ruling. What do you think of that editor's assessment?
It's definitely the doomsday scenario, I think, if you value a diverse workforce. But I think it's a little premature. I think the priority for employers right now should be to really figure out what's the best way to build a diverse workforce, no matter what happens in the colleges. So maybe you need to broaden the scope of the schools you're looking at. Maybe you need to look at, more regional schools, more community colleges, et cetera, and really work harder in the recruitment process to find the shining stars. And given how competitive admissions is anyway, I think a lot of employers have been doing that regardless. And as a parent of a college-aged, child, I would say where you go to school is actually less important than it's ever been to employers. They're more interested in what your skill set is and, what you studied and what you've done and how the story all comes together for a particular candidate rather than did you go to Harvard or not.
Well, for college-age kids listening, I'm sure that's great news. But in the wake of this ruling, what's your advice to employers? What proactive steps, aside from that recruitment advice, should they be taking?
Employers should be looking at their policies regarding hiring, recruitment. They should be looking at what training they provide to individuals, within their company who participate in these processes. So what kind of questions can you ask a candidate? Can't you ask a candidate? What do job descriptions look like? I think all of these things need to be revisited with an eye to potential challenges, because we know there are groups out there who are looking to set up employers to come after them and say, oh, you're discriminating against, white applicants, or, your DEI program is illegal. So I think companies are already working with their attorneys and their consultants to look at their programs, how they're described, what the objectives are. They're doing things like avoiding specific numbers that provide, that could be misinterpreted as quotas. So there are steps that employers should be taking. I'm certainly not advocating for employers to just sit back and ignore these decisions, because even though they're not directly applicable, we know that there are groups out there who want to bring this fight to the workplace.
Something that you just said that startled me is someone coming after a company saying your DEI programs are illegal. Is there any there, or is that just a scare tactic?
Well, I think a lot of these efforts are just pure intimidation tactics. I mean, I referenced an attorney general's letter earlier. If you read the letter carefully and you look at the sources they cite to, it doesn't even stand for what they represent in the letter. So someone could receive that letter and be very scared and intimidated by it. It's signed by 13 attorney generals. These people should know what they're talking about. But there are scare tactics, and then there are groups who dig in and send in false candidates to probe and see, what companies are asking and what they're looking for. So if you're an employer, you need to make sure that the people on the front lines, the ones who are conducting the interviews, are not saying things that are inappropriate or not saying things that would misrepresent what you're actually trying to do in a hiring process. So this is a time for employers to, really sharpen the skills of those individuals and make sure that they're in compliance all across the board.
Peter Rahbar, per usual, thanks for coming on and thanks for your insights.
Great being here. Thank you.